Next item of business. Children, Criminal Proceedings and Young Offenders Legislation Amendment Bill 2025, resumption of the adjourned debate.
Thank you very much. I call the member for Ballina.
Thank you, Mr Speaker. I rise to speak on behalf of the Greens on the Children, Criminal Proceedings and Young Offenders Legislation Amendment Bill 2025. And to say at the outset that the Greens oppose the bill. At this stage, we will be moving amendments in the Legislative Council, but we note that the Aboriginal Legal Service, the Civil Liberties Council, the New South Wales Bar Association and the Justice and Equity Centre came out this week with serious concerns about this legislation. As I said earlier today, the common law principle of Dolly Incapax, which is about really the safety of children in many regards, protecting children, is to codify that is one thing, but to make to the implications that we've heard from the second read and smarter people than me outside of here, including the Civil Liberties Council, as I say, and the Bar Association and the Aboriginal Legal Service, are all telling us that it's actually has made it more difficult and for young people to access diversionary programs, and that the ability to rebut the principle that children aged 10 to 14 do not have the presumption that they do not have the capacity to comprehend the moral wrong, the mens rea, that is required to convict someone of a crime. And to rebut that in the common law has always, there's always been procedures for that and guidance from judges. We know that the review that took place earlier this year, in good faith, we thought, the New South Wales review to review presumption that children cannot be guilty of criminal offences. The review earlier this year into Dolly Incapax that the Attorney General led. We were shocked to come to this place at the beginning of the week, and I believe that all of those organisations that I've mentioned were also very shocked, because what they thought about codifying the common law and strengthening, or if you like, and extending the Young Offenders Act to include more diversion, which is very welcome, and we welcome that part of this legislation. But they were really, really shocked, as we were, to see the implications and certainly to see the Attorney General virtue signalling about locking more the ability to rebut the presumption and lock more children aged 10 to 14 up. And indeed, when we see the conga line of nationals MPs that are going to be speaking, and I'm not discounting the regional and rural crime that is happening, particularly with young people, but you know there's something seriously wrong, in my view, and the Greens' view, that they are welcoming this and want it to go harder. So, Mr Speaker, we opposed urgency on this bill, and I take the opportunity to say how appalled we were about the process. And indeed, the Aboriginal Legal Service have said the same thing. We'll have a lot to say in the other place. Our spokesperson, Sue Higginson, MLC, has done a lot of work on this, and we will have a lot to say, and we'll have a lot of amendments. Turning back to this bill that codifies in statute the common law principle of Dolly Incapax, I want to note that I also have relied heavily from analysis by the Aboriginal Legal Service and Emma Starr in a recent report that she gave to Sydney criminal lawyers. Mr Speaker, the government claims that this bill implements the recommendation of the expert review to codify the common law principle of Dolly Incapax in legislation. However, the Attorney's second reading speech and the government's media release make clear that the bill actually weakens Dolly Incapax by making it easier for police to rebut the presumption that children aged 10 to 14 are not capable of forming criminal intent due to their stage of intellectual and moral development. And that is an argument that has been made by lawyers around intellectual and moral development, and the implications that have been suggested to us by legal experts is that is now going to be that is not able to be made, that argument. The bill does this by changing. How does it do that? By changing the type of evidence prosecutors need to adduce to rebut the presumption. For example, it's no longer mandatory for prosecutors to adduce evidence about the individual child's intellectual and moral development. And when we think about the two pieces of proving a crime has occurred, there's the act, and none of us would disagree that there are heinous acts happening. There are. It's a fact. I'm on the Law and Safety Committee, and I note the chair is here. It's an excellent committee doing excellent work for 2 years now, inquiring into regional youth crime. Heinous acts are occurring, but that's only one part. That is not the intention. The other part is the mens rea, the intention, having the moral sense to know that what you're doing is morally wrong, not merely mischievous, not merely naughty, but morally wrong. And I don't need to go into that, but it is a fundamental principle of criminal law. So it's no longer mandatory for prosecutors to adduce evidence about the child's intellectual and moral development, which is absolutely pertinent. Absolutely pertinent. I've worked with children in prisons, or in juvenile justice centres who have fetal syndrome. That has affected their moral development. These are so vulnerable. When you think that a child under the age of 14 cannot consent to antibiotics. They can't consent to antibiotics. Why? Because they're not seen as being old enough to make that decision about their bodies. But we are saying that children under the age, that 11 and 12-year-olds, that we should decide that they understand what is morally wrong. The Greens' position is that we should absolutely be lifting the age of criminal responsibility to 14. That would keep us in line with the rest of the world. When the Attorney-General points to jurisdictions in Australia, well, we're sorry, we don't think looking at Queensland in particular is a great idea. Australia's approach to child criminal responsibility is increasingly under global scrutiny. International children's rights bodies, including the UN Committee on the Rights of the Child, recommend a minimum age of at least 14. And that is our policy. We, as I say, Mr. Speaker, even short periods of time in custody exponentially increase the likelihood that the children will go on to cycles of future offending and imprisonment. We know that most youths aged 10 to 14 that police charge and take to court are Aboriginal, 54%. These laws will predominantly harm Aboriginal children and fly in the face of government's commitments to closing the gap. As I say, the parts that relate to the Young Offenders Act we welcome, but this is backwards. We should be, if we want to say that, even if we were to say that it's mandatory for children under the age from age 10 to 14 to be diverted, do it. But this is what this is going to do, and also what was so concerning to me was the Attorney-General was saying that the percentages since the High Court case, that the percentage of children aged 10 to 14 that the rebuttal of the presumption was not successful was a bad thing. How is that a bad thing? We've got to look at it much, much more deeply. And I know that my colleagues in areas with high youth crime at the moment will say that it's about the victims and it's about the acts. Well, yes, it is, absolutely. But that's half of proving a criminal charge. That is half. And no one is denying that many of those incidents are heinous. But this is about the moral sense of doing something wrong. And if a child's intellectual capacity cannot be taken into consideration, well, what we're going to see, and that's what we're being told by the Aboriginal Legal Service and others, is that we're going to make it easier to punish and convict the very small number of children aged 10 to 13 that come into repeat contact with police. The government should be focusing on preventing crime in the first place by meeting the needs of these children, their families and communities through meaningful and sustained investment in community infrastructure, services and therapeutic alternatives to police and courts. This is the age group that we should prioritise. This is the ones. For every educator in this place, for anyone who's ever worked with children, you know that is the crucial time. We know it's early intervention, it's earlier, but surely that is the time for us to put all our energy into diverting them from prisons. I'd like you to look at your 11-year-old child and imagine them in that world. They must, of course there has to be a consequence. Of course there has to be serious consequences. But our current prisons, our current juvenile justice centres is no place for 11-year-old children today in this country. We oppose the bill.